Okay, here's what's happening right now. Across California, renters are being separated from their pets. Some are giving them up because they moved into a no-pets building. Some are being hit with pet rent that doubles the cost of having an animal. And almost all of them have no idea there's a federal law that could have protected them.
Wait, what?
Yeah, and here's the thing. You don't have to be moving to be at risk. Your current lease could change. New management could take over. Tomorrow, your landlord could decide your dog is too big or too loud or just no longer allowed. So today, we're breaking down the law California renters need to know, the 30-day deadline almost nobody knows about, the pet rent ESAs are exempt from, and one company that's actually doing this right.
Oh, let's go.
Because two things keep happening in this state. People find the apartment they want, the landlord says no pets, and they walk away. Or, even worse, they're already living somewhere, the lease changes, and now they're being told they have to give up their dog.
Oh, yeah, that is brutal.
It is brutal. And the part that really gets me, the part I want people to hear, is that for a lot of folks, that dog is not optional. It's not a luxury. The animal is helping them function. Anxiety, depression, PTSD, emotional support animals do real work for real people.
100%, totally.
So I want to make sure people know there's an actual path here. And it's not the path the internet thinks it is.
Wait, what do you mean?
So there are two kinds of animal accommodations in this country, and people mix them up constantly. Service animals, like a guide dog, are protected under the ADA. They can go into restaurants, on planes, into the grocery store with you. That's a specific thing, for specific disabilities.
Yeah, the vest dogs, right.
Right. Emotional support animals are completely different. ESAs are not protected under the ADA. You cannot take your ESA into Trader Joe's. You cannot bring your ESA into a restaurant. That's not what this is.
Oh, that's interesting.
What ESAs are protected for is housing. That's it. The Federal Fair Housing Act says if you have a licensed therapist's letter documenting that an emotional support animal helps with your condition, your landlord generally has to accommodate the animal, even in a strict no-pets building.
So it's a housing law, not a public access law.
Exactly. And here's the part most people don't know. Financially, landlords also cannot charge you pet rent for an ESA. No pet deposits, no monthly pet fees, none of that.
Wait, really?
Really? If your apartment normally charges $50 a month in pet rent, plus a $500 pet deposit, plus a pet cleaning fee at move-out, that's all gone with a valid ESA letter. Same FHA protection.
That's huge.
In California, with the cost of rent, that pet rent alone is hundreds of dollars a month you're saving, just for having the right paperwork.
Damn.
And this is why the people abusing the system are such a problem. The ones taking obvious, untrained dogs into restaurants with $20 Amazon vests on. The peacock on the airplane.
Oh, the peacock, yeah.
The little dog sitting in a stroller in the grocery store. Those people are making it harder for the people who actually need this protection.
Yeah.
Because real ESA protection, under the Fair Housing Act, is not about taking your dog to bars. It's about keeping your apartment and not paying double for it.
Okay, so how do you actually do it right in California?
Okay, so in California, this all got tightened up in 2022. A law called Assembly Bill 468. Before AB 468, you could pay $40 on a sketchy website and have an ESA letter back the same afternoon. Some of them were literally generated by software with a fake digital signature.
Oh, of course they were.
California killed that. Now, to get a valid ESA letter in California, the therapist has to have an established client relationship with you for at least 30 days before they can issue the letter. They have to be licensed in California. They have to do a real clinical evaluation.
So no more same-day letters. That's wild.
No more same-day letters. The whole letter mill business model is illegal in California now.
Okay, that's actually really good.
It is good. But here's the issue. People don't find out about the 30-day rule until they've already signed the new lease. The landlord says no pets. They scramble, and they realize, oh, I needed to have started this a month ago.
Brutal.
So if you are even thinking about moving in the next few months, or if you have any sense that your current lease situation might change, or you just don't want to keep paying pet rent, start talking to a licensed California therapist now. Today, the clock starts ticking the day of your first session.
Yeah, that's the move.
That's the move. And listen, if you genuinely benefit from being around your pet for your mental health, that is a real thing. The law protects you. You just have to play it by the rules. And the rules in California require time.
Don't wait.
Don't wait. Which, actually, this brings me to the sponsor for today's video, CheapESALetterCalifornia.com.
Oh, okay, hit me.
And listen, I know the name says cheap, but cheap does not mean shady. These guys play it by the book. Every clinician on their roster is California licensed. Every letter they issue follows AB 468 to the letter. The 30-day clock starts the day of your first session. Real evaluation, real follow-up, real documentation.
Oh, so not a letter mill.
Completely not. They're called cheap because they're not charging you $200 for a same-day PDF that doesn't even hold up. They're charging fair for a real letter that actually works under federal housing law.
Got it. Love that.
So if you want to keep your dog or stop paying pet rent, start that clock with them now. CheapESALetterCalifornia.com. Don't wait until it's too late.